Good morning, everyone. Good morning.
Good morning, sir.
Yeah, good morning. Class captain, are you there? Is the class captain there? Is the class captain here? Okay, so we are going to start, so we don't really lose much time. Um, the last class we were looking at the memorandum and articles. First, we weigh in on the significance of registering that document under Section 46. And of course, we saw the contractual implication of those documents. Once they are registered, they create a contract between the company and members, the company and officers, the companies, yes, members, officers, and all of that, and even directors. Well, the directors are part of officers anyway, and also a contract between the members and the officers, among themselves. So, or even the members and members, inter se is a contract. So whatever binds them, are forcible and stuff like that. So, and of course, why not? Why would it not be a contract? When you look at section 27 now, we saw section 27, and you saw what the section talked about, the concluding part of the memorandum, that it has to be, that it will be, let me just read it to you. It talks, it talks about it as it being a deed. You see, subsection 6, 2027, that the memorandum shall be stamped as a deed. That is the highlight of an agreement, a very serious one at that. Okay. And of course, we looked at the relationships between the memo and the memo and the article, so we look at the relevant provisions, particularly section 40, 49, section 51, 52, and also section 53. We looked also with regards to the rights that section 46 affords. I don't want to lose this class because of Akintola, Abiola, Samuel. Please mute yourself and excuse us. You are disturbing the peace of this class. Whoever knows Akintola, Abiola, him or her is disturbing our peace, is disturbing our peace. If she comes to this class regularly, she should know what she's doing is wrong. Okay. So we did say, we did touch on alteration. I asked you to look at section 49. Then we also we also saw the concept of entrenchment. I asked you to look at the implications of entrenchment. We explained it really, where you can move some provisions that are in the ordinarily should be in the articles, you transfer them to the memo, and then you preserve them there by either providing that they could only be altered with some special conditions or not being able to be altered at all. And we also looked at, the enforcement of the articles and memo. And then we talked a bit about insiders' rights and outsiders' rights. Who are insiders? Who are outsiders? But before 1990, because I did mention to you that Section 46 is just a repetition of Section 41 of CAMA 1990, and that Section 41 of 1990 CAMA was a big innovation over what the law was under the 1968 law. Because under that 68 law, there was the issue of the need to know who are insiders, who are outsiders in the enforcement of memorandum or articles, of association. Insiders are members, and it is only insiders that can enforce their rights by just that are preserved for them in the articles of memo by simply tendering that document. But you may be an insider and a right is conferred on you as an outsider. If you are a shareholder, for instance, and you are also a director, those are two status, two statuses. And then, so if a right is given to you as a director, that right is not given to you as an insider, but as an outsider. And under that law, the 68 law up to 1990, you cannot, enforce that right by just tendering or referring to the article. You must produce a separate contract that right, is embedded in that before you can be able to enforce it. So that is, what the problem was. Now that you have the version of 1990 retained in 2020, you can see that whether you're a member or officer, if a right is conferred on you, you are treated as if you are insiders already, and therefore you can enforce these rights. You can enforce these rights. And then we went as far as subsection 3 that says that if the article or memo confers a right on anyone or any person to remove or to appoint a director, that person will be able to enforce that right, notwithstanding that the person is not a member. So you can see the power of enforcement or even reform of the law to simplify those things, because it used to be a technical matter that you are trying to enforce a right and you have an objection, and once the objection is taken and the case law covers it, that right is done. But what we have in Section 46, which used to be Section 41, CAMA 1990, is just a reform that has brought some peace, in the area of enforcement of rights. So we looked at all of those, and then of course we did more on understanding some of the relationships that we have, the provisions. Particularly, we did focus on alteration of memorandum section 50. We looked at section 49. In section 49, in terms of how memo can be tampered with. And then the contents of memo too, we saw it, and the significance of those issues. And of course, we then, went ahead to look at how, the impact of section 41. If you are going to alter your business object or your object, you go through section 51, and the process is there, very long process. So any aspect of memo that you want to alter, clearly you can do it so long as you comply with, the provisions in 50, 51, and yes, 51 and even 52. Then we looked at section 53. We thought that section 53, is in relation to alteration of articles. And that brings us to the model articles. What is the status of a model article? There is someone that is raising up, is Aunt Mercy Uzo.
Good
Uzo.
morning, sir.
Yes.
Good morning, sir. Sir, I have a question, sir.
What is it?
Okay, my question is, you have taught us that there's a difference between of the business of the company and the object of the company. That business relates to companies limited by shares, while object relates to companies limited by guarantee. But I wanted to ask, I don't know, sometimes reading text or reading some material, it appears that they use it interchangeably sometimes. They might say the object of the company, but in actual sense, they are talking about the things that the company can do. So I wanted to know, is there a different sense in which object is being used? And also, there was a time I interned with a firm and I assisted in drafting their memo. And what they put there, it was a company limited by shares, but they put the object of the company, and they listed some of the things that the company will do, which was to provide computer services, etc. So I wanted to know if there's a different sense in which object is being used, or if it's just a misconstruction of the sentences. Also, the comma section 35 that provides for
Make your
statement of
make your make your make your question very brief. We are just starting today's lecture, so
okay, sir.
please
Okay,
make
sir.
it very brief so that we can address it.
That's my question, sir. That's my question.
Okay. Now, you see, I'm happy you are working with people out there. There is nothing like knowing what the law is, because these things are not invented. They are not invented. And if you knew how all these provisions come about, you understand that those who are using it interchangeably, they are wrong. Businesses are meant for companies that are incorporated for business, for profit. And that business for profit can only be via limited liability companies by shares. It must be limited by shares. Okay? Those are the ones that have businesses, authorized businesses. Remember that most lawyers, when they are to draft memorandum, they just call for a precedent that has been in use for years. And what they do is they change names, they change all those things. There is no innovation, there is no peculiarity, there is no domestication. Okay, so when they talk about objects before, before now, Nigeria, object was the language. You must state your object in, in the memo. It used to be called object before 1990. So if you lay your hands in the library, go check the 1968 Companies Act of Nigeria, you will see that what was used then was object. It was changed. The nomenclature was changed following the recommendation of Gawa. I told you, if you are familiar with the 1963 Act of Ghana, which was provided for them, or which they were held by Professor Gawa to put together. It was there that the idea of object, and businesses were separated to, to separate, those companies that are limited by guarantee because they are not for profit. So they only have objects to pursue, whereas the ones that are for profit, they're actually in business to make money for themselves. So that is where the nomenclature of business is, and the legislature adopted it. They haven't made the mistake to have said that in section 27 that you should state your businesses. Let us see the language so you see that it is not by chance or just enjoying themselves. That's why they said, now listen, the nature of the business. That is, if you look at the starting point, the memorandum of association of every company shall state, see, the nature of the business or businesses which the company is authorized to carry on, or if the company is not formed, look at that language, if that company is not formed for the purpose of carrying on business, the nature of the object or objects for which it is established, it couldn't be clearer than this. If you are working there and you're not back into your class, this is your class now. And in this class, we look at things much more differently than people out there look at things. We are not flippant. We are looking at the law and the implication. The source of how this one came is what I just stated. And if you have a report of Professor Gawa that he wrote in 1961, you will see all of those. In fact, most of the provisions of CAMA 1990 came from that particular exercise, okay? With exception of certain areas that you don't need now. So you can see that it is not using it interchangeably. Section 27(1)(c) does not indicate a permission to use interchangeably. It is too clear. Okay, so if you see problems tomorrow, this kind of thing, you can correct it on the authority of knowledge of this thing. That is why you pay attention to what we do here. Know it, internalize it, own it, and then let it be yours to apply out there. Okay, I think that addresses your concern. So if you have any other concern, maybe we have some time before we go. You raise it, we address it. Okay. So we discussed lastly. We discussed section 53, and there are certain issues I raised that I told that you should ponder on alteration of articles. To start with, the beginning says that subject to this act and to the conditions or other provisions contained in its memo, a company may, by special resolution, alter its articles. So you can see the preeminence of memo over the articles, because which means really, if the memo say you can't do anything in the articles, you can't change, and you can't change it. But of course, articles is always alterable. You must be able to alter it. There is no law, there is no company that has the power to foreclose alteration of his own articles. It's not possible. If you want some provision not to be altered, you take it away from articles, send it to memo. That is the practical part of operating companies, or the act itself, the application. Okay, it looks academic, but the truth of the matter is that it is supported by these provisions. How many people remember section 52 subsection 1 and 2? I don't think there are many people who remember or even thinks about these sections. But these are what the sections empower, enables, practitioners to do. But it is only your time now in class that you are reading CAMA, you are getting to know things. Many people are practicing, don't come back to start reading CAMA as we're asking you to do. That they don't bother. So, but of course, those are where the gaps are. It's only those who know that can firmly, make a point and stand on it, to be corrected. So that is justice. So what we are going to do here, and I wonder whether the class captain is back here. Are you here? The class captain is staying here. Okay. If it's not, no problem. Now, I want us to look at this particular capacity of the company. The capacity of the company relates to what the company is authorized to do. So you determine a company's capacity not in virtue or by reference to section 43. That is about the powers of the company to operate as an independent person, pursuant to section 42. The capacity relates to what the company operations can do. That is where we talk about your businesses or your objects. So objects and businesses, as the case may be. And when I say as the case may be, that is if you are for non-profit limited by guarantee, you have objects. If you are for profit limited by shares, you have businesses. So the law says state what you want to do there. I was trying to tell you what section you have to read before today when my internet went off and I never had any communication with your captain. So I could give the rest of what you guys to read. You could put it on your platform, but that didn't happen. So that's not a problem. So we are looking at the capacity of the company and what is the capacity we have. Yeah, okay. The capacity is not more than what we have just read in 27 to state the businesses or business that you are authorized to carry on. That particular provision is a replica of Section 27(1) of 1990 CAMA. I will read it so that you know that it is coming from somewhere. It is not an innovation, it's a retention. They are retaining it in the 2020 Act. So Section 27(1) has always been there since 1990. So let us just read it before we go on explaining. Now, I'm reading from Section 27 CAMA 1999. It says, C, it's the same C. The memo of every company shall state, C, the nature of the business or businesses which the company is authorized to carry on, or if the company is not formed for the purpose of carrying on businesses, the nature of its object or objects for which it is established. That is the object, that is the business. This particular section is what establishes the capacity of a company. That defines what kind of business a company registered under the Act can do, what kind of object a company that is incorporated, limited by guarantee, can do. The law says, state it. The company should state it. So our law asks you to determine your capacity. They are not giving you capacity. They say state it in your memo. Because memorandum is also a public document that you must file with the CSA. And once you state it, the law says you cannot go outside the capacity you have defined yourself in the memo. In the memo. That is how it has been since 1856 till 1968 till 1990 in Nigeria. It has been that way since we started having general incorporation legislation from UK, which we have been copying. So you can see, if we are still reading the language of 1990 in 2020, we are still glued. Most countries have changed. What does it mean for you to have the capacity that is defined by Section 27, subsection 1C? It simply means that you have a limited capacity regime. If you are asked to state what you are to do in your business that you want to carry on in your memo, it simply means that outside of that, you cannot do it. And let me then read again in 1990, because these are things you need to understand together as we transit into 2020. And you see some mistakes that is happening, so you understand where all of those things. It may not make much sense to you now, but you will get it. You get it. Now, I've read Section 27 telling us companies to state the nature of business or businesses which the company is authorized to carry on. Now, when you go back to section, let's see, section 39. Now, so once you define your capacity by stating the object or the business, then anything that you do outside of the capacity you have defined for yourself, we will call it that it is ultra vires. It's ultra vires. That is what it is. And any ultra vires act is void. So if a company were to do a business or carry on a business other than those which it has led the public to believe is carrying on, that transaction or business will be void. Section 39 reads, 1990 now, before I move on to 2020. And you must pay attention to these issues and the nomenclature, that I'm bringing to. Subsection 1 says, 39, 1990, CAMA. A company shall not carry on any business not authorized by its memorandum, and shall not exceed the powers conferred upon it by its memorandum or this act. Or this act. A company shall not do any of this, because if it does so, then that the doing of it is void. Now, I will go on to also read more of that. It says, subsection 2, a breach of subsection 1, that is, you cannot do or conduct any ultra-vires act. Ultra-vires acts are acts of businesses that are not that you have not empowered yourself in your memo. It says a breach of subsection 1 of this section may be asserted in any proceedings under section 300 to 313 or under subsection 4 of this act. That is the implication of not complying with your capacity as you frame it under section 27(1)(c). You can see there is no way as a student of company law you can read section 27(1)(c) without reading section 39. And what is compulsory, because we are talking about ultra-vires. Now, in those days, because companies didn't want to be limited, so what they did was that they would state so many, and as I said, the language object used to be for all companies, whether limited by guarantee or shares. We started changing it in 1990 to push object to limited by guarantee and push business to limited by shares companies, okay? So, Ashbury Railway versus RISI, for those of you who have had opportunity to read, the capacity of companies, you would have had an explanation in the text about what it means and the historical aspect of it and the implication of the case of Ashbury Railway versus RISI. You will find those cases and read them. It's about enforcement of Ultra-Vires Act. It is void, okay? And everybody is affected. The third party is affected. The third party are supposed to go and see what to have a capacity to do in the registry, CAC. If they didn't go, that is their luck, but they must go to advise themselves. But then it got to a point when lawyers in those early days were able to not limit themselves to one or two. They would state so many objects that they could do. So many objects they could do. They even would state so many powers until powers are generally given in terms of section 43. It wasn't like that. Powers and objects were all stated in diverse dimensions in the memo. Okay, so to give the companies the ability or that leverage to do many things in case businesses climate change, okay, they will release about 10 different objects. Some are even more than that, okay? So, and it became an issue in the case of, so when they do this, the question therefore is that where does it leave? Where does it leave the company? The judiciary or the courts used to look at whether apart from your first object, the other ones are read in the likes of the first one listed. So lawyers created a device by inserting a clause in the memo. After they have listed about 18 objects or businesses, then it was object. They will now insert what we call Cotman versus Browham's clause. Cotman versus Browham's clause, empowering that all of the listed objects should be read independently of one another and treated as if each of them represented the object of an independent company. It became an issue to be tested in the courts. It went as high as the House of Lords, and the House of Lords affirmed that that particular drafting style was enforceable. So it became a popular practice that in order not to limit companies, lawyers, practitioners, after listing so many object clauses or business clauses, they will now add what we call a Cotman versus Browham clause, which calls on the court, on the public, to treat each of those clauses, like 20 they have listed in the memo, as if each of them represent an object clause of an independent company, and therefore not to be read one in the light of other one, the first one. It was approved by the House of Lords, so it became a standard practice. So if you get a memo precedent, you will still see a list of so many object or business clauses, and at the end of that clause, you will see a Cotman versus Browham's clause. There are two clauses that is in use: Cotman versus Browham. Cotman, C-O-T-M-A-N as pronounced, Browham, B-R-O-U-G-H-A-M. The citation you will find in the textbooks, okay? So that was acceptable. So you can see people, what the lawyers were trying to do was to limit the effect of ultra vires doctrine and its application. Since Braham's clause is now acceptable practice, so it was difficult for anybody to say what the company did, the company had no power to do. It was difficult. Now, the second approach that practitioners used to, to meddle with the rigidity of the ultra vires doctrine was to incite what we call what is this now? There's a clause, I'm coming. Bell Brothers Limited versus City Wall Properties Limited. Okay, let me just confirm that. So two of those ones you need to go also read. I will explain the implication of that clause to you, but you want to know all of them, the two, before we go back into the grammar and see the implication of this one. Okay. Okay, now the first one, as I said, it Cotman versus Browham. Cotman versus Browham. I want to believe by now you should have got to that point, because these are the introductory part of this. You will find Cotman versus Browham in 1918 appeal cases 514. Cotman versus Browham 1918 appeal cases 514 for the principle I explained to you earlier. The other one is Bell Houses Limited versus City Wall Properties Limited. City Wall Properties Limited, 1962, 2 KB 656. Bell Houses Limited versus City Wall Properties Limited, 1962, sorry, 1966, 2 Queensbridge, KB 656. Now, what does the Bell Houses clause mean? The Bell Houses clause is a clause that empowers, confers on directors the power to carry on any business which, in their opinion, they consider that it could be carried on along with the object of business of the company. That is what we call the Bell Houses Limited versus City World Properties Limited. Those two clauses, if you find them in the memorandum, we appear to remove, or tie a company down to what is in the statement of business clause in their memo, because one allows them to do so many things which they have listed, and courts must not interpret even the last one in the light of the second one. So they can list unrelated businesses. You're into fashion, you want to go into sports, you want to go into, to so many things. Music, you want to go, then there are so many disjointed, unconnected. The Cotman versus Braham will allow the company to carry any of those clauses or businesses on without the court limiting the last statement in the light of the first one. The Bell Houses clause versus City World Properties confers on the directors the power to do any business, not even anyone listed now. In the case of Cotman, you must have listed. What is the issue is that whether you can do any of those that are listed that are unconnected with the first one. The second one is that even for the ones you have not listed, the directors have the power and opinion, to carry on any business, which in their opinion, they consider could be carried on with the business of the company. So if the directors say that, well, in our opinion, we can just well do this with our business, that is it. And again, the Court of Appeal affirmed the correctness of that particular device. So those two devices were used to neutralize the impact of Ultra Vires Act. And what does that mean? Limiting the impact. That is making sure that whatever it is that they do, the director decided to do, will not be held as Ultra Vires. So it was being used to give wider leverage to the company, but also it was also a benefit for the third parties who may not know that this was Ultra Vires. So you can see that even at invention, the Ultra Vires rule is a common law rule to ensure that companies stay limited to their object. And the reason why it was necessary for companies to stay limited, focused on their object, was that people invested in your company believing that this is what you want to do, fashion, and they believed you. So now you have started, you have their money, you are going fishing business. What has fishing business got to do with fashion? So it is then possible for other people to raise the issue that this is Ultra Vires. You cannot do it. Members are also empowered to challenge the directors that they cannot do Ultra Vires business because the memo didn't allow us to do it, or hasn't allowed us to do so. This is the stage. This is the stage. After a while, countries decided to look into the whole essence of having a limited capacity, of business, of the limited capacity for companies. We are looking at it. Canada, Australia, New Zealand, they all changed their approach. How did they change it? All they wrote was that memo, you don't have to write any business in your memo. It's simply 2 lines in a legislation that an incorporated company have the capacity to do any lawful business. That is it. So it does away with all the nonsense of so many clauses in the in the article, in the memo, whether one was Ultra Vires, whether one is not Ultra Vires, whether the Cotman versus Braham would apply or it would not apply, whether the Bell Houses Limited clause would apply or it would not apply. They were gone by simply empowering them to do whatever it is they could do that is lawful. Straightforward. So all the discussion about ultra vires is gone. However, why they are permitting companies to do any lawful business, they also empower companies that those business that if the company now identify a particular business that they will not do, then that's one business they will not do. So they still allow them to limit. They've given them, a blank check now, except they limit it in a particular way. They can do anything. So the one they cannot do is the one they have limited. Some companies limit themselves, some don't. So anything they do is lawful, that is lawful is okay. So because they also limit or empower companies to limit itself, and the company has limited itself, they have kept ultra vires in their pocket to the extent that they go over to those ones that they have said they will not do. They will do everything, but this one we won't do. If they don't go back to it, it will be ultra vires. So that also have an impact. Even at that, legislatures were working. So you can see now that in our 1919 CAMA, it was possible, and we have an issue with limited capacity. That is what companies had, because we are to state what we will do. So what we have not stated, we cannot do. We state what we do in line with the directive of Section 27(1)(c). But what we didn't state, we will not be able to do. Those ones will be ultra vires. And that will trigger, if we do any one of those we have not stated, it will can trigger what I read out to you as Section 39, subsection 1 and 2. So in 2006, UK changed its own law. UK had led us all our life. We had followed them, follow all our life up to 2006. But in 2006, no, up to 1989, 85, 89. In 2006, they were tired of their own life. So they reformed, extensive reform of the accompanying legislation. What did they do? I'd ask you to go see Section 8 of Companies Act of 2006 of UK. Has anybody seen it? Is there somebody here who has actually looked at it? Section 8 and 9, 10 of CA 2006 UK. Is there anybody? Anybody at all? Who has looked at this? Oh, goodness.
Yes, sir.
Oh, God. You did?
Yes, sir. Section 8, actually.
Ah, God bless you. God bless you. Ah,
Block.
thank you. Thank you. Who else, apart from Nuruddin, who else looked at it? This is a class of 300. Hey, you guys are joking with fire. Ah. You think I'm playing? So how are you going to follow me? Who else has seen Section 8? Oh. Now, Uzo, I just want somebody to say I also saw it. Uzo, did you see it?
Yes, sir. I've seen it, sir.
Is it just now or before now?
I've seen it too.
Before now, sir. Before now, sir.
Before now. I want people that have said, if the class says before now, I'll be so happy, but don't lie. I don't want you to deceive me, because sometimes when you deceive me and I believe you, you get yourself into trouble. So let me start with Nuruddin. There's no time to this time is sometimes not enough. So can somebody among those who saw it, Can somebody talk to us about it briefly? What did you see?
Okay, I'll go first, sir.
Even if you don't get it right, I'm okay with you. Just seeing it, you are okay with me. Oh. Please, just say what you want to say.
Okay,
Okay,
so
fine.
okay, yeah. So what I observe is that Section 8 of the UK Act has done away with most of the things, if not all, that we have in our own Section 27 here. So the memo, for the UK, is required by Section 8 to contain two things, and the first of which is that, there must be a statement, that the subscribers wish to form a company under the Act, and then the second one is that there must be a statement that they have
We
agreed
take
to
one
become
shares.
member. Yeah, agreed to become members of the company and then take shares, in the company. So that's at least one share each. So those are the two things. So it has kind of, taken the power that the memo has in Nigeria. Yes. So the power that memo has in Nigeria, it does not have that kind of power under the UK Act. So that's what I observe, sir.
Yeah. God bless you. What's your name again, Joe?
Nuruddin Ibrahim, sir.
God bless you. So,
Amen.
who else, apart those two other people, Uzo and the other person, if there are anything you can add to what Nuruddin said, please let me know. You can quickly do so because, he has really helped this class.
Hello, sir.
Yes.
Yes, sir. My name is Messi, sir. I live in my area. I don't have anything else to add to what he said because the Section 8 of the UK Act already, what they listed as what the memo should contain are things that are inconsequential. And then the importance that memo has in Nigeria, memo does not have that sort of importance in UK. So it appears that UK is also moving away, like other countries of the world, to allow companies to do businesses that even though they don't list businesses that were not listed in their memo. It's similar to what you said already, sir.
Okay. So, there's another person. There's another person. If he has anything to say, I also am listening. So you can see what your colleagues have said, and this is why it is very important to follow the class and read. For those of you who still think that whatever if the class the teacher doesn't give, there is nothing else we can give. Am I to start writing that you go and see Section 8? You are too old in the law now not to be able to not to be proactive. This is how people learn. But for those who really check this thing, they know what I mean. They are happy to say their mind, and I'm happy that they restated it very well. All said, I had introduced this issue to you and to let you know that UK had done away with memorandum. So the issue of capacity is no longer a problem. It's no longer a problem. And so what does the UK, now that where the object used to be under the UK law was memo. Now that there is no memo and only just two inconsequential clauses or paragraphs will be in the memo now. So where in this act does UK now define its capacity? Its capacity. Those are the areas I wanted to tell you to go look at before I had issue with network. Unfortunately, your class captain didn't get in touch with me. That's this thing just went, whether you are still speaking. I had about 3-4 minutes then, but I didn't get anything. Now, I want you to go to Section 31 of UK. Section 31 of UK. I want you to go there. For those of you who have it, so also, do you have the electronic version before you?
Yes, sir, I have it.
Very good. God bless you. I don't know why
Amen,
you
sir.
always have everything. You and Uzo and the other man. That's good. Now, I want you to read for the benefit of your colleagues. Maybe you can motivate them to go and do this one. That you are not performing miracle, you are just doing what you should do as a diligent student. Read it for me, section or for the class.
Okay, sir.
Section 31. Read it.
Okay, section 31 provides for statements of company's objects. So
Okay,
subsection 1
now,
provides that
go
unless
ahead.
a company, okay, subsection 1, unless a company's articles specifically restrict the objects of the company, its objects are unrestricted.
Very good. Just stay there.
Okay, sir.
So you can see this one that they just read is not the same as section 27.1, is it? For those of you who understand section 27.1c, this one that is read by Newton is not the same language. There are two different issues. It says, unless a company article specifically restrict the object of the company, its objects are unrestricted. This is a style that is used to confer unlimited capacity on company. It is now, even before I go on, this section 31.1, my class, how do you categorize it? You can see how the classification of provisions provides the instrument through which you can unlock these provisions. If you know the classification, you will know how it works in real life situations, or it should work in real life situation. How do you classify it first? Section 31, subsection 1. Yes, classification first, and then definition next. Who can help me classify this thing?
It's
the default
the default provision.
Let me see. Now, who is that Oluwapelumi? Who is?
Good morning, sir.
Are you the one trying to talk?
Yes, sir.
The same set of people. Okay, go ahead, my dear.
Sir, it is a default provision, sir.
Why do you say so?
So from the provision of that subsection, you can see that this section allows the company to restrict its capacity, but ordinarily its capacity are not restricted. So if the company does not restrict its capacity in its articles, then it has the capacity to perform any business or object.
Now, it is a default provision, and that is correct. It says, unless a company article specifically restrict the object of the company, the objects are unrestricted. The underlying rule and in a default rule, in a default provision must be identified. The enablement must also be identified. So the underlying rule that is going to be mandatory, if nothing is done with it, is from the last comma. From the comma, its objects are unrestricted. That is the rule there. That is the rule there. Its objects are unrestricted. What is the empowerment clause usually found in a default provision? The empowerment clause is the beginning of that sentence, unless a company article specifically restricts the object of the company. Unless. They are not bound to. Those who don't understand don't have to restrict, but those who understand will restrict. But the rule there is that the objects of a company will remain unrestricted. Once it is unrestricted, it's an unlimited capacity. So because this is a default provision, you can tag it as a default unlimited capacity regime. So the UK has a default unlimited capacity regime. That's what the UK has now under section 31. Other companies don't even have these ones. They'll just say, a registered company, can carry on any lawful business. That is all. Any lawful business. Now, so this is what the UK, in moving away from the 27(1)(c) style, which they have been doing since 1856. What you saw in section 27 that we are reading of CAMA 1990 or even CAMA 2020, they have been doing it, they have been copying it in their legislation, every legislation since 1856, 1862. It's been like that in 1985. It's only in 2006 they got tired and they changed it to this you are looking at. That is why they dealt away with the memo. Okay. Now, in our own, what happened? So for UK to be able to adopt this, now they dealt away with memo. They dealt away with memo. Now, I want you to go to your CAMA. Go to section 35, please. Somebody should read it for me. This is local one now, not foreign one. Oh, yeah.
Section
I want somebody
35.
to read it for me.
Section 35.
Yes.
Statement of company's object.
Yes.
Sub 1. Unless a company's articles specifically restrict the object of the company, its objects are unrestricted.
Stop there. So this, having read this 35, what is your opinion here? What's the name that the person that read it? What's your name?
Balikis.
Huh?
Balikis.
Balikis.
Yes.
So what is your opinion? How do you feel that you just read what we read a while ago in UK? You just read in your own law. How do you feel, please? What's
I
your
feel
feeling?
they are similar.
Huh?
I feel the two sections, the section 31(1) of UK Companies Act and 35(1) of CAMA, they are similar.
So if they're asking you, where do you think Nigeria got this 35(1), what will be your answer?
What do you think? So
what
I
will
didn't
be
hear
your
what
answer?
you said.
That if I ask you now,
Yes,
where
sir.
do you think Nigerian legislature got this our section 35 subsection 1? Where?
From UK Companies Act 2006.
From what? From what?
UK's Companies Act 2006.
God bless you. Now, what did I tell you that the UK legislature had to do to be able to come up with this 31(1)? What did I say they did?
Sorry, sir, I don't remember.
Okay, you have tried. But there are some people in the class who will remember. What did I say the UK needed to do to get this version of section 31 subsection 1? Yes, others who remember.
Sir, you said they did away with the memo in section 8.
God bless you. I said not that even that I said so, but we saw that they did away with memo in terms of containing object clauses. Memo used to contain object clauses. If you want to be sure of that, you just go to section 80, section 8 or so in 1985 UK legislation. It's there. They did away with it. As I said, it had always been for years, over a century. That's what they've been doing, over a century. So they did away with object clauses in memo. Then we continue our interrogation. Did Nigeria do away with memo or object clauses?
No, sir.
Did we?
No, sir.
No, sir.
Huh? Now,
No,
if
sir.
it is no, sir. Okay, good. If it is no, sir. Now, I told you that the UK version we have here is called Default Unlimited Capacity Regime. It is default, it's unlimited regime regarding the company's capacity. So how would you describe our own under section 37(1)(c), 27(1)(c)? I described it before now. I told you that what we were using under section 27(1)(c) is what? How did I describe it, class?
A mandatory rule, sir.
It's mandatory, but in terms of capacity, I said it was a limited capacity regime. It was limited capacity regime because you will state what you want to do. Anything not stated, you cannot do. Because you have the capacity to limit, you are empowered to limit yourself, and it is mandatory. You state what your business is, and anything not stated, you cannot do it. You cannot do it. Okay. Now, so what has come to the fore is that Nigeria appears to be running two shows. We are running both shows. We are running the limited capacity. We are also running the unlimited capacity. Are you seeing it?
Yes.
Yes, sir.
If section 27(1) is different from section 31(1) and 35(1), and the two of them are in our law, there's a problem. It is a problem. Can we now be running two opposing capacity regime pari passu? UK did away with the zone. That would have created a problem. That the limited capacity regime that the UK had, they did away with it. In place of it, they put up section 31(1), which is the unlimited capacity regime, default unlimited capacity regime. But we kept our own together. And when you keep two different opposing capacity regime, what are we bound to have? What are we bound to have, class?
Confusion.
Huh?
Confusion.
Conflict or confusion.
Contradiction.
Contradictions, conflict, confusion. You can describe it anyhow you want, because you don't even need me to tell you, because you are people of words. You don't need me to describe it for you. I have given you the template to think, to say what you see. UK changed to 31(1). In doing so, they did away with the equivalent of section 27(1)(c), which they used to also have. We wanted to be like UK, yet we made an effort by putting in place section 35(1). What we didn't do was that we didn't remember that UK, in doing so, had to take some preliminary steps to open the way forward for a 31(1) provision. That step that UK did, it is obvious to you now, students, that Nigeria refused or omitted to do so, either because we didn't know that they are related and very unrelated. They are they are contrary one to the other. So, to me, section 35(1) looks to me to be a strange fire. It's either because those who are involved in this thing didn't know the implication of what they did. They ran through UK and saw this thing and they grabbed it. But the housekeeping that UK did, they overlooked it. They didn't know. Because if they knew, they would have had to do away with section 27(1)(c). They didn't know. Now, let us go further. And I hope you are following these things. Because if you are not following it, hey, you are not following it, it's very interesting though, very, very interesting. And I wish you are following it. Okay. Now, look at Nigeria. Go back to section 53, subsection Well, now, okay, before we even get there. Now that we have section 35(1), and we also have section 27(1)(c), let us now see the equivalent of how Nigeria was trying to do away with or to treat ultra-virus. Can we go to section 44, subsection 1? Go to section 44, subsection 1. Go to section 44, subsection 1. Oh, yeah.
Section 44. Effects of
Common 2020. Yes. Read the. Yes, read the title of that section. The marginal note. What is it?
The title says Effects of Ultra-Virus Act. Subsection
Okay, now,
1. A company, sir?
Wait. I just want you to announce to your colleague that that's 44(1) was for the effect of ultra-virus. Before you read, I read it before. I want to read again what we had in 1990 when we read the ultra-virus to you. When I first read it to you, I read section 39 to you, and I want to reread it now. It says, here's what it says. So with our 27(1)(c), this is how the legislature accurately treated it. It says, a company shall not carry on any business not authorized by its memorandum and shall not exceed the power, even we don't even need that. A company shall not carry on any business not authorized by its memorandum. Now, the reason is because they have asked you to state what you want to do in your memo in 27(1)(c). So if you do not state it, anything not stated is not authorized, and therefore it becomes an ultra-virus business. In contradistinction, if you can do all for under the UK, the language is different in the sense that unless you change or you restrict your object by your articles, your capacity to do is unrestricted. That is, it is unrestricted. Now, let us now go to section 44, subsection 1. So we look at it, and I want you to watch out for the language that is used under section 44(1). Yeah, go ahead and read it.
Section 44(1). A company shall not carry on any business expressly prohibited by its memorandum and shall not exceed the powers conferred upon it by its memorandum or this act.
Now, wait, you can now see that in 2020, we are trying to copy section 39. I just read section 39 because I'll read it again for you to know. And when I'm reading it again and again, I hope you students are noting it again and again, so that when you go home, during the holidays, you cannot ask yourself, Prof said these things again and again. What exactly it is? Because some of you will never read this thing after today, just that you are gone. And I don't want that to happen. I want you to understand this thing. It is not science. We are conversing here, and I want you to follow it. Now, this is 39 again. I will read it with my own voice. I don't know whether it makes any difference. A company shall not carry on any business not authorized by its memorandum and shall not exceed the powers conferred upon it by its memorandum or this act. So it is practically the same, except for the first phrase. Now, the 44 now says, a company shall not carry on any business. To that point, it is the same thing. This is where it changes from the word expressly prohibited by its memorandum. Now, go back to 27(1)(c), please. This is, a company shall not carry on any business expressly prohibited by its memorandum. Go back to 27(1)(c) and ask yourself whether that language permits prohibition of anything. Somebody should read section 27(1)(c) to me again.
Section 27(1)(c).
Yes.
Let me start from 1. The memorandum of association of a company shall state, sub C, the nature
It's
of the
okay.
business or businesses which the company is
It's okay.
authorized to carry.
It's okay. It's okay. Just that. Reread it again to that point. I said it's okay. Reread it for me to that point. I don't want to read everything. Just do those ones I said you should raise. Okay. Go ahead.
Should I continue, sir?
No, restart it again. Just reread it.
Okay. 27 sub 1. The memorandum of association or I should just go to C straight.
Mm.
The nature of the business or businesses which the company is authorized to carry on, or if the company is not formed for the purpose of carrying on business, the nature of the object or objects for which it is established.
Okay. Now, I ask you this question. From what you have read, does section 27(1)(c) in the memo, does it allow us to prohibit anything? Does it allow company? Is that what the directive in subsection 1 says? Subsection 1 says that the company shall just understand it again. He said the memorandum of association of every company shall state. It shall state the nature of the business or businesses authorized to carry on. That is what it says.
Yes, sir.
Now, the related provision of Ultravirus now said a company shall not carry on any business expressly prohibited. Does section 27(1)(c) anticipate that we shall expressly prohibit anything?
I don't think
No,
so.
sir.
I don't think so,
No.
sir.
Okay, what is section 27 looking for, to which the memo in 44 relates? What is 27 looking for?
I feel 27 is saying you must state what you can do, while 41 is now saying the things you stated you can do are the only things you can do. Anything outside what you stated in your memo is ultra-virus the capacity of the company.
Thank you. Thank you. God bless you. What I wanted you to say, you almost said it, is that section 24(7) is asking companies to state, not prohibit, to state the business or businesses that it is authorized to carry on. By implication, anything not so stated is prohibited. By implication, anything not stated is deemed to be prohibited, because that is what will be ultra-virus. So the business of 27(1)(c) is not to prohibit. And how many things are you going to prohibit? It cannot be to prohibit. It only says state what you need to do, because that will be what you state will be your capacity. So if you don't want to prohibit anything, then you will have that clause. It will run into 100 pages. Yes, it will run to 100 pages because you want to do everything. So, however, when you state 2, 3 things, anything that you have not stated is prohibited by implication. So you now see how section 44, the legislature, they are being clever by half. And that is why the language of section 44(1) is different from the language of section 39(1) of the 1990 CAMA, because they are trying to accommodate this issue of expressly prohibited. There is not like expressly prohibited under section 20, because section 44 is supposed to relate to section 27(1)(c). The related provision of section 27(1) is section 44(1). But 44(1) is addressing something that section 27(1) does not require. does not demand. This is where our problem starts. It has started from missing it out by grabbing Section 31 of UK law, making it Section 35 of Nigerian law. Again, from the ultra-virus language, they're asking us that companies shall not do anything expressly prohibited, when indeed the related provision doesn't say you prohibit, it says you state. There are different things. State is different from prohibit. If I ask you to tell me what you like, or to ask me what you want me to do for you, or what questions you want me to set in an exam or in a test, am I asking you to tell me what I will not, what you don't want me to set? I said, tell me what you want me to set as questions for you. Maybe 6. I'm not asking you, I say state, tell me, not what you prohibit. And these things are very crucial for analysis, very, very crucial for analysis. How our legislature is bungling these things, commingling different divergent capacity when all we need is just one. Section 27 was one. They commingle it with UK law and put it as Section 35. Now let us go back to Section 53 now. Let us go back to Section 53. So you start, you keep on understanding the dilemma they have put you as students, because you are going to be the one to address this issue. If there are questions, there may be, you have to unravel it. So they created it for you, not me. So, Section 53(1), can somebody read it?
Subject to the provisions of this Act and to the conditions or other provisions contained in its memorandum, a company may, by special resolution, alter or add to its articles, including deletion or modification of the provisions stated in Section 27, subsection 1, subsection A to D.
Now, can you see the problem again? They now say that a company, Section 53 deals with operation of article, and they were stating it as it was in Section 48 of 1990 CAMA. Because if you don't know these previous provisions, you will not know how we started to goof and start missing the point. Here at Section 48, this is what it is of CAMA 1990. But this is where it is. It says, subject to the provisions of this Act. I'm reading 1990 now, so you can see how similar it is until they bring in strange fires. Now, subject to the provision of this Act and to the conditions or other provisions contained in its memorandum, a company may, by special resolution, alter or add to its article. That is all. To add to its article. That is what that section is meant for. But what happened? They now say, apart from adding to its article, they say, including deletion or modification of the provision stated in Section 27(1) A to D. We read it last class, and we saw that to alter, to start with, the beginning of this particular section is to put the memo under the article under the memo in terms of primacy. Then suddenly it says that in changing your articles, you can now even delete or modify the provisions of 27(1) A to D. What does that mean? When the Act has told you under Section 50, maybe we saw the 50 yesterday, we have been told that all of this modification, 51 deals with alteration of business or object, and you are going to alter that object by complying with Section 51, which requires you to even take the court's approval. You can't change the object of memo without going to CAC, and even the court has to approve. But look at what 53 says. By the article, without recourse to the court, delete everything. Doesn't make doesn't make much sense. You know, is the confusion not getting worse and worse? Because now this 53 is already overriding so many provisions of alteration of memo. Okay, because now you can even delete the name of the company. If you delete the name of the company, so what name are you going to give the company? They're not asking you to say and that one, they say delete. If you delete the name of company, what happens? So what will be the name of the company going forward? Now, and yet the law says that if you now want to alter also the object, or you delete it or modify it, where does it place section 51? Where does it place section 51? So these are the kind of issues that you face when you are dealing with capacity of the company under CAMA 1990. You have to know what it was, sorry, CAMA 2020. You have to know what was in the 1990 CAMA for you to understand the problems that are inherent in CAMA 2020. And that is what we've been struggling with for the past 1.5 hours. I don't know. What I know I have succeeded in doing is to bring these issues to the fore for you to understand. Whether you actually understand, I don't know. But at least I know that some of you have been listening, some of you have been participants, you know, and some of you have also read some of these provisions, particularly the UK one and the CAMA one, and you are seeing it as we go along that it is not so straight. You know, intellectually there is a conflict, you know, and then in terms of seamlessness, some of these things are not seeming right. Section 44 is irreconcilable. Section
You people are going now because all of this faithfulness, see our full of water, too many challenges. We still come ourselves. So the water is too much.
Well, I'm going. Let me hand over you to your class. That one. So please let the class captain. Let the